day to everyone. I am Jabel Alahmad A. Lamalan of JD3 Tolentino, and today I am going to present to you a case report which discusses forensic evidence, particularly paternity DNA testing. So, to start with, I chose the case of INRE, the writ of habeas corpus for REYNALDO De Villa, who was detained at the new Bilibid Prisons in Muntinlupa City, and June De Villa as the petitioner-relator versus the director of the new Bilibid Prisons as the respondent. Now, on to the specifics of the case. We have here the precedents wherein petitioner Reynaldo De Villa, joined by his son petitioner-relator June De Villa, sought for a twofold relief. First, that respondent director of prisons justify the basis for the imprisonment of petitioner Reynaldo, and second, that the petitioner Reynaldo be granted a new trial. These reliefs are sought on the basis of purportedly exculpatory evidence gathered after performing deoxyribonucleic acid or DNA testing on samples allegedly collected from the petitioner in a child born to the victim of the rape. Prior to this petition, by a final judgment of the Supreme Court dated February 1, 2001, in the case of People v. Reynaldo De Villa, petitioner Reynaldo was found guilty of the rape of Eileen Mendoza, his niece by affinity, and sentenced him to suffer the penalty of reclusion perpetua, and ordered him to pay the offended party civil indemnity, moral damages, cost of the suit, and support for Lealyn Corrales Mendoza, the putative child born of the rape. Petitioner is currently serving his sentence at the new Bilibid prison in Muntinlupa City. As to the recurring facts of the crime, the following are established. During the trial, it was established that sometime in the third week of April 1994, at about 10 in the morning, Eileen Mendoza woke up in her family's rented room in Sagad, Pasig, Metro Manila, to find petitioner Reynaldo on top of her. Eileen was then aged 12 years and 10 months. She was unable to shout for help because petitioner covered her mouth with a pillow and threatened to kill her. Eileen could not do anything but cry. Petitioner succeeded in inserting his penis inside her vagina, and after making thrusting motions with his body, petitioner ejaculated. This encounter allegedly resulted in Eileen's pregnancy, which was noticed by her mother, Leonila Mendoza, sometime in November 1994. Upon confrontation, Eileen revealed that petitioner Reynaldo raped her, which prompted Eileen's parents to bring her to the Pasig police station, where they lodged a criminal complaint against petitioner Reynaldo. Dr. Rosalyn Cosidon, who examined Eileen, confirmed that she was 8 months pregnant and found in her hymen healed lacerations at 5 and 8 o'clock positions. On December 19, 1994, Eileen gave birth to a baby girl whom she named Lealyn Mendoza. In his defense, petitioner alleged that at the time of the alleged rape, he was already 67 years old, so much so that old age and sickness had rendered him incapable of having an erection. He further averred that Eileen's family had been holding a grudge against him, which accounted for the criminal charges. And finally, he interposed the defense of alibi, claiming that at the time of the incident, he was in his hometown of San Luis, Batangas. However, the regional trial court found Reynaldo guilty beyond reasonable doubt of the crime of qualified rape and sentenced him to death, to indemnify the victim in the amount of 50,000, to pay the costs of the suit, and to support the child Lealyn Mendoza. Upon automatic review of the Supreme Court, it was found that the date of birth of Eileen's child was medically consistent with the time of the rape, since it was never alleged that Eileen gave birth to a full-term 9-month-old baby. It is given credence to the prosecution's contention that she prematurely gave birth to an 8-month-old baby by normal delivery. The judgment of the RTC is affirmed with modifications that Reynaldo is sentenced to suffer the penalty of reclusion perpetua and ordered to pay the offended party 50,000 as civil indemnity, 50,000 as moral damages, costs of the suit, and to provide support for the child, Lealyn Mendoza. Now, on to the present case. 3 years after the promulgation of the Supreme Court decision, the Supreme Court is once more faced with the question of Reynaldo de Villa's guilt or innocence. Petitioner-relator in this case, June de Villa, is the son of Reynaldo. He alleges that during the trial of the case, he was unaware that there was a scientific test that could determine once and for all if Reynaldo was the father of the victim's child, Lealyn. Petitioner-relator was only informed during the pendency of the automatic review of petitioner's case that DNA testing could resolve the issue of paternity. Such information was apparently furnished by the Free Legal Assistance Group or the FLAG Anti-Death Penalty Task Force, which took over as the counsel for petitioner. Thus, in the petitioner's brief in the case of People v. De Villa, he sought the conduct of a blood type test and DNA test in order to determine the paternity of the child allegedly conceived as a result of the rape. However, this was implicitly denied in the decision of the Supreme Court on February 21, 2001. Another partial reconsideration motion of the decision, wherein it was once more prayed that DNA tests be conducted, was denied with finality in a resolution of the Supreme Court dated November 20, 2001. Hence, the decision became final and executory on January 16 of 2002. However, June de Villa was undaunted by these challenges. Having been informed that DNA tests required a sample that could be extracted from saliva, June asked Billy Joe de Villa, a grandson of Reynaldo de Villa and a classmate of Lealyn Mendoza, to ask the latter to spit into a new sterile cup. Lealyn readily agreed and did so. Billy Joe took the sample home and gave it to petitioner-relator June de Villa, who immediately labeled the cup as container A. June then gathered samples from 4 other grandchildren of Reynaldo de Villa. These samples were placed in a separate container with distinguishing labels and temporarily stored in a refrigerator prior to its transport to the DNA analysis laboratory at the National Science Research Institute. During the transport, the containers containing the saliva were kept on ice. Now, petitioner-relator requested NSRI to conduct a DNA testing on the sample given by Lealyn Mendoza, those given by the grandchildren of Reynaldo, and that given by Reynaldo himself. The identities of the donors of the samples, save for the sample given by Reynaldo de Villa, were not made known to the DNA analysis laboratory. Now, to give us a general idea on how paternity DNA testing is conducted, here is a short clip of my good old friend Molly from Crystal Health Group.
Hi there, it's Molly from Crystal Health Group. Today I'm going to answer your question, how do paternity tests work? During a DNA paternity test, different genetic locations are analysed along the DNA molecule. A person possesses 2 of many possible alleles at each location. The alleles are identified by a number, and these are inherited from the parents at conception, one from the mother and one from the father. Therefore, when the DNA profiles of biological parents are laid out together, one of the child's numbers should match to a number from the mother's sample, and one should match to a number from the father's sample. If these alleles match at all locations analysed, a person is included as the biological father of the child, as it proves they have the genetic markers that they passed on to the child at conception. Inconsistencies, locations where there is no match, will exclude the person as a biological father. This is based on the fact that it is only possible to pass on to your offspring the alleles which you possess in your own DNA profile. More information is available on our website, or you can call 0800 988 7107 to speak to a clinical advisor. Thanks for listening, and look out for our other. Hi there.
Now, after listening to Molly's explanation, we now know that when the DNA profiles of the parent, in this case the father, are laid out together, one of the child's numbers should match to a number from the father's sample. However, after testing, the DNA laboratory rendered a preliminary report on March 21, 2003, which showed that Reynaldo de Villa could not have sired any of the children whose samples were tested, due to the absence of a match between the pertinent genetic markers in petitioner's sample and those of any of the other samples, including Leah Lynn's. Which brings now to the issue related to the topic. So the issue is whether or not a new trial to consider newly discovered evidence is proper and may be ordered by this court in view of the results of the DNA tests conducted. Now, I know you guys are bored stiff in some way or another, but here I have something for you to think about. So hear me out on this, okay? We have here a skit which I named plus minus simple. This connotes how the presence or absence of a simple, or shall I say, a minute thing can affect our perception of truth or false. Basically, it boggles with one's perspective. So let's proceed. Now, so what do we have here? It's a horse. I know everyone's mortified by how artistic it is drawn, but please bear with it. Now, given that there is this horse, what if we add a single line in the middle of the horse's body, like this? Now, the question is, what does it give us? I'll give you 5 seconds. Now, for those of you who are able to guess what this is, yes, it is now a two people dressed as a horse. See how this single line made the horse into two people? Well, if it is weird, then here comes the next. Now we have here a snail, a very, very humble snail. But what if we add a vertical line under this nail, like this? Now, think about, what does it become? Now, it becomes a lollipop with a disgusting worm coming out of it. See? From a slowpoke to sweet. Oh wow. Okay, another. Oh, same lollipop with the disgusting worm. So how about adding this line perpendicular to that one we previously added, like this? What do we have here? Now we have a suicidal snail. Ay, nala. Ang kuhol na himog lollipop niya, ibalik na sab naging pessimistic na kuhol, ay nalangkit. Anyway, the next one is somewhat also a dramatic change. Here, we have a guy or someone who's throwing a ball. Simple, right? But what if we add a vertical line in between the hand and the ball, like this? Now, what does it become? Now, the guy is reaching for a doorknob. Lol. Now, and taking it to another level, not just adding a line, but also rotating the picture 90 degrees to the left, like this. Now, what do we have? We have a sad boy drowning at sunset. See? Now, you may be asking, How is this relevant to the topic at hand? Well, now, the relevance of this skit in the topic in hand is that, well, aside from its not so comedic purpose, I say that this also serves as a reminder and a recognition to the work of those engaged in the field of forensics, such that even the minute or simplest things in the perspective of a common person bear so much importance to them. Imagine in this same case being reported, it as the spit or the saliva or whatnot. Diba? Kapila man nga sig dupla sa isa kadlaw, murag wala lang man sa kuha. But little did we know that such a simple, minute, or as irrelevant matter as a spit bears so much significance to producing evidence of one's paternal relations. Butsilingon ragudani kay sa forensics bisan ginagmay ra nga mga bagay enough na nasa ilaha. Kontento na sila para mabuhat nila ilang mga trabaho. Parang imong ex lang manggod ang dili makontento ba? Maong nang itaglay. Ay, charot ra oy. Pabitaw ko ex. Anyways, too much for that skit. Now we proceed to the Supreme Court's ruling, wherein the petition was denied for lack of merit. In brief, petitioner relies upon the DNA evidence gathered subsequent to the trial in order to relitigate the factual issue of the paternity of the child Lealyn Mendoza. The SC reiterated that it must be stressed that the issue of Lealyn Mendoza's paternity is not central to the issue of petitioner's guilt or innocence. The rape of the victim Eileen Mendoza is an entirely different question, separate and distinct from the question of the father of her child. In one of the cases ruled by the Supreme Court, it was held that the fact or not of the victim's pregnancy and resultant childbirth are irrelevant in determining whether or not she was raped, because pregnancy is not an essential element of the crime of rape. Whether the child which the victim bore was fathered by the purported rapist or by some unknown individual is of no moment in determining an individual's guilt. In the instant case, however, the Supreme Court noted that the grant of child support to Lealyn Mendoza indicates that where the decision was based, at least in a small measure, on the victim's claim that petitioner fathered her child, if this was given credence by the Supreme Court, and in fact, as a finding of fact, was affirmed by the Court of Automatic Review. So, the fact of the child's paternity is now in issue, centrally relevant to the civil award of child support. It is only tangentially related to the issue of petitioner's guilt. However, if it can be conclusively determined that the petitioner did not sire Lealyn Mendoza, this may cast the shadow of reasonable doubt and allow the acquittal of petitioner on this basis. Be that as it may, it appears that petitioner once more relies upon erroneous legal grounds in resorting to the remedy of a motion for new trial. A motion for new trial under the revised rules of criminal procedure is available only for a limited period of time and for very limited grounds. Under Section 1 of Rule 121 of the revised rules of criminal procedure, a motion for new trial may be filed at any time before a judgment of conviction becomes final, that is, within 15 days from its promulgation or notice. Upon finality of the judgment, therefore, a motion for new trial is no longer an available remedy. In addition, the grounds for a new trial are enumerated under Section 2 of Rule 121. The grounds for a new trial, according to Section 2, are the following. First is that errors of law or irregularities prejudicial to the substantial rights of the accused have been committed during the trial. And second, that new and material evidence has been disproved which the accused could not, with reasonable diligence, have discovered and produced at the trial, and which, if introduced and admitted, would probably change the judgment. In this case, the petitioner anchors his plea on the basis of purportedly newly discovered evidence, i.e., the DNA test subsequently conducted, allegedly excluding petitioner from the child purportedly fathered as a result of the rape. A motion for new trial based on newly discovered evidence may be granted only if the following requisites are met. First is that the evidence was discovered after trial. Second, that evidence could not have been discovered and produced at the trial even with the exercise of reasonable diligence. Third, that it is material, not merely cumulative, corroborative, or impeaching. And lastly, that the evidence is of such weight that if admitted, it would probably change the judgment. So, in this instance, although the DNA evidence was undoubtedly discovered after the trial, it is nonetheless a fact that it does not meet the criteria for newly discovered evidence that would merit a new trial, because such evidence disproving paternity could have been discovered and produced at the trial with the exercise of reasonable diligence. So, petitioner-relator's claim that he was unaware of the existence of DNA testing until the trial was concluded carries no weight with this court. Lack of knowledge of the existence of DNA testing speaks of negligence, either on the part of petitioner or on the part of petitioner's counsel. In either instance, however, this negligence is binding upon petitioner. It is already a settled rule that a party cannot blame his counsel for negligence when he himself was guilty of neglect. A client is bound by the acts of his counsel, including the latter's mistake and negligence. It is likewise settled that relief will not be granted to a party who seeks to be relieved from the effects of the judgment when the loss of the remedy at law was due to his own negligence or to a mistaken mode of procedure. Even with all the compelling and persuasive scientific evidence presented by petitioner and his counsel, the Supreme Court is not convinced that Reynaldo de Villa is entitled to an outright acquittal. As correctly pointed out by the Solicitor General, even if it is conclusively proven that Reynaldo de Villa is not the father of Leilyn Mendoza, his conviction could in theory still stand, with Eileen Mendoza's testimony and positive identification as its basis. It was also reiterated, and correctly so, that the pregnancy of the victim has never been an element of the crime of rape. Therefore, the DNA evidence has failed to conclusively prove to this court that Reynaldo de Villa should be discharged. Although petitioner claims that conviction was based solely on a finding of paternity of the child Leilyn, this is not the case. The conviction was based on a clear and convincing testimonial evidence of the victim, which was given credence by the trial court and was affirmed on appeal. Now, in conclusion, the petition was dismissed for lack of merit. That would be all. Thank you.